Honorable members, I want to welcome you to this morning's sitting.
On Tuesday, 20th May 2025, Parliament passed the Uganda Peoples Defence Forces Amendment Bill 2025 that will see civilians tried in the courts martial.
Right Honourable Speaker and Honourable colleagues, this law is about civilians who voluntarily acquire arms, equipments of violence. This law is also about the civilians who voluntarily masquerade as militants. This law is about those who would commit offense with the military or with the help of any military officer to be tried as proposed. Right Honourable Speaker, I want to dispel the fear that this law is targeting 45 million Ugandans. That's a lie. This law is targeting those people who have preoccupation in their minds to commit offense against Ugandans. This law is to protect Ugandans, the vulnerable Ugandans, against violent people who have firearms or who behave like military personnel.
The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence.
We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect of human rights. The minority unanimously are of the opinion that the General Court-Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offenses, even if committed by members of the Uganda Peoples Defence Force.
The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary.
This law should not be clouded by only discussing the issue of civilians. If a soldier rapes a person in the barracks, if you remove any other written law, then that means the court-martial cannot try that soldier. Likewise, if a soldier came out and shot people in the bar, the court-martial cannot try that person. Now, we must be mindful that the court-martial, we propose that the court-martial should try all offenses committed by soldiers. What we are capping, the limitations we are putting, are situations where the court-martial has to deal with civilians. Now, with the civilians, you have a limitation. But for soldiers, if they commit an offense, they should first be tried by the court-martial, and then they can appeal to the Court of Appeal and then move on to the Supreme Court.
I put a question that the Uganda Peoples Defence Forces Amendment Bill 2025 be read a third time and do pass. Those in favor say the court.
Order, Madam Speaker.
Ayes have it.
The Uganda Peoples Defence Forces Amendment
Madam Speaker,
Act
order on Honorable
2025.
Kasaija.
Title settled and the bill passed.
During the sitting, the House also passed the Political Parties and Organizations Amendment Bill 2025 that conditions government funding for political parties on their commitment to democratic principles such as tolerance, dialogue, and peaceful coexistence.
The object of the bill is to amend the Political Parties and Organizations Act, Cap 178, to restrict government funding and other public resources provided to political parties and political organizations that are represented in Parliament to only political parties and organizations that are members of the National Consultative Forum, to provide for the Inter-Party Organization for Dialogue and the Forum for Non-Represented Political Parties and Political Organizations as organs of the National Consultative Forum.
The committee notes that since the intention of the bill is to condition receipt of funds on the commitment of political parties and organizations represented in government to the principles of tolerance, dialogue, and peaceful coexistence, using the word National Consultative Forum as proposed in Clause 1, will extend the application of the provision to other political parties and organizations otherwise not represented in Parliament. The committee is therefore of the considered opinion that Clause 1 should be redrafted to require government to only provide funds to other political or other resources to a political organization or party organization if the political party or organization is a member and participates in activities of IPOD. The committee recommends that funding to political parties should be conditional on the adherence of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence as proposed in Clause 1.
The bill in Clause 2 proposes to institutionalize IPOD as an organ of the Consultative Forum. The Consultative Forum is currently created under Section 20 of the Principal Act. The National Consultative Forum shall have two organs. A, the organ, and I underline the word organ for emphasis, the organ for political parties and political organizations with representation in Parliament, which shall be known as the Inter-Party Organizations for Dialogue. And B, the organ, I highlight again, the organ for political parties and political organizations without representation in Parliament, which shall be known as the Forum for Non-Represented Political Parties and Political Organizations. It is clear from the written submissions of the movers of the bill and their one-man ally, Mr. Serwambala, that the bill imposes a charge on the consolidated fund. Parliament is stopped from proceeding on any bill or a motion for that bill that imposes a statutory charge on the consolidated fund. This is in Article 93 of the Constitution and Rule 130, Sub-Rule 1 and 2 of the Rules of Procedure. The minority finds that the Political Parties and Organizations Amendment Bill 2025, privately moved by the Honorable Nakut Faith Loru, Honorable Mutembuli Yusuf, and Honorable Afidra Ronald Olema, violates Article 93 of the Constitution of the Republic of Uganda, and therefore it is unconstitutional.
While the expenses expected to be used, the money is already in the budget. So what I understood from that there was no imposition. Government had already provided money. This bill is simply reorganizing. It's just simply reorganizing what already exists. So there's a National Consultative Forum for which money has been provided to run the affairs of the National Consultative Forum, and the bill seeks to reorganize the National Consultative Forum.
Does it have an effect on the money that we have always allocated?
No, right, Honorable. That's our understanding. That doesn't have any other charge.
We have been providing for a budget for political parties. This exists in the budget which we are running now and the budget which we passed on Thursday. What this law is requiring is conditioning access of this money to certain rules and standards.
I move that a motion that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read for the third time and do passed.
I put a question that the Political Parties and Organizations Amendment Bill 2025 be read the third time and do pass. Those in favor say on the contrary, nay. The ayes have it.
A bill for an act titled the Political Parties and Organizations Amendment Act 2025.
Title settled and the bill passed. The House adjourns
Madam
and
Speaker.
dine.